car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
And welcome to the Attorneys. I'm Art Franklin, your host. So glad that you chose to join us for this show. And we're going to get right into the topic of Miranda rights, warnings, how and when they apply. This guy right here, you know who he is from Hollis, Wright. This is Carter Clay, and we've got a very special guest with us, Elizabeth Hunter. So glad to have you with us.
Thank you for having me.
Yeah, we want to jump right into this, Carter.
Yeah, so we've got a great, interesting topic, one that we've never covered before on the show. Of course, we've done a lot of shows over the years on criminal law and criminal procedure and the process that individuals who are charged with crimes can expect to go through. But we're going to do a deep dive tonight into the Miranda rights. And of course, everybody knows what the Miranda rights are in a general sense, because if you watch television shows, Law and Order, or any shows that involve criminal law at all, we hear about the Miranda rights. We hear about you have the right to remain silent. Anything you say can and will be used against you, etc. But what exactly does that mean, and how did the Miranda rights come about? Now, thankfully, I don't know about the Miranda rights from personal experience, but being a lawyer and watching TV, I've heard a little bit about it. But I guarantee you there are a lot of people watching the show tonight that have been charged with crimes and have had their Miranda rights or been given a Miranda warning that will be interested in this topic. And you are right, we've got Elizabeth Hunter here with us to do this deep dive and to kind of navigate these waters. Elizabeth, thank you so much for joining us.
Thank you for having me.
Yeah, tell us a little bit about the nature of your legal practice, first of all.
Well, it's Elizabeth Hunter Law Firm. It's actually located downtown Birmingham, which is, I believe, maybe 2 blocks from here. It is just solely criminal defense. I may have some civil rights and personal injury cases, but I'm actually just trying to go strictly to criminal defense. And we range from traffic citations to felonies, capital murder, rape, robbery, all of that, and maybe some appellate cases, but that's about it. Yeah.
Now Miranda is the name, refers back to a U.S. Supreme Court case, right? That was decided many, many years ago, and addressing the issue of whether or not a person charged with a crime and in custody had to cooperate, had to talk to the police, right?
Yeah, correct.
And talk a little bit about that case and what arose from that case and the holding in that case.
Yeah, so it was Miranda v. Arizona, and it was a 1966 Supreme Court case. And basically, in a nutshell, it was it established that law enforcement had to inform people of their rights. I mean, the rights were always there, to remain silent. You had a right to remain silent, as well as a right to have counsel, of course. And then they go further. Anything that you say will be held against you in the court of law. And although they were there, it's just that people weren't informed of that. So after that Supreme Court decision, it was obviously law enforcement. They were required to provide those rights, which turned into those Miranda warnings. And of course, there's some gray area as to when they were applied, but just in a nutshell, those are those rights.
And talk about just sort of some practical reasons as to why that opinion or holding came about. And what I'm getting at is that there had been a history, I guess, of individuals being charged with crimes that were being unduly influenced. They were undergoing maybe some coercive tactics, interrogation tactics, and things of that nature. And I guess the Supreme Court's holding wanted to make sure that people were aware of those rights, that they were educated on the spot, and to make sure that they did not have to go through the process that perhaps the police were asking them to go through.
Yeah, of course. I mean, and that kind of goes into when they would apply. And obviously, it's, for one, you have to be in police custody, and then it goes into the interrogation. And I get this all the time. My clients come to me and say, my Miranda rights were violated. And that's not necessarily the case until they, for one, have been arrested. And there is some gray area, and there has been some gray area. There still is some, but just recently the courts have established maybe some fine line and kind of narrowed their approach a little bit from that 1966 case.
Yeah, so what's interesting is in a lot of these television shows you watch, you see that the police will ask individuals that they suspect of committing the crime.
Yeah.
They haven't arrested them, but they ask them to, quote, voluntarily come down to the police station and have a chat with us,
Yeah,
right?
yeah.
And that would not satisfy the two elements of Miranda, because if you're voluntarily there, right, you're not in custody. And so they would not have to read you the rights under those circumstances. Is that correct?
Yeah, correct. I mean, and one of the incidences, and my clients, they tell me this, and just the reason why they contact me is the officers will call them on the phone and say, hey, I just want to hear your side of the story. That's like the most common thing that law enforcement says. At that point, you're not even in police custody. You're not even at the station. But whatever statements that you say to them, obviously they would be admissible.
Yeah.
And then we have situations where they're asking, well, just come on down to the station. Let's just have a chat. And then at that point, you're actually kind of initiating the contact with law enforcement, which would go into the voluntariness. So I think with that said, I just tell my clients, just don't say anything at all. But at the end of the day, though, I can see why it would be an issue to not speak with them, because then it seems like you're guilty. But at the end of the day, though, I say best case scenario, just don't say anything, contact me, and we'll kind of go.
Yeah, a lot of times in those setting arts on the show, you'll hear them say, am I being detained here?
Exactly.
Right.
And then they'll respond like, no, you're free to go. And then so that clearly means you're not in custody.
Yeah.
But
Right. Okay, I'll go home then. Don't talk to me right now. But there are times, though, where people feel like the Miranda laws the rights were not given properly. What do you do in that situation if you feel that they didn't properly read your Miranda rights to you?
Well, are you talking about the right to remain silent and things like that? I think that's important. And even after that, I think people negate the most important part, which is, do you understand these rights? And oftentimes they'll just say yes and then just start speaking. And I don't know if that's one of the issues where they're just going through it and not necessarily stating them verbatim. But regardless, though, it's more of an objective standpoint. If they don't know, they have to let them know that they don't know. But more often than not, they don't. And then it's after the fact. Then it's up to us to try to get those statements out of court. So
what if they fail to give you the rights at all?
Well, it will be a violation then, but it also depends on where you are. Obviously, if you're in police custody, it has to be coupled with interrogation, not just an interview, or you can't just volunteer statements or even address questions that the law enforcement didn't even really ask pertaining to the offense. So it's all relative, but at the same time, no, all that matters is if they're trying to elicit information out of you and you are in custody, then that would apply. And if they don't give those warnings to you, then it would be a violation.
Yeah, and Art, I know we're about to go to commercial break, but I think it's important for the viewers to understand this, and that is if they fail to read you your Miranda rights, that doesn't mean that your criminal charges are going to be dismissed.
Yeah.
Right.
All it means is that whatever information you provided to them, if they failed to read you those Miranda rights, those comments and statements made by you may ultimately be inadmissible. But the prosecutor can try and prove the case without those statements. So a lot of people may be wondering, well, I want my case dismissed, and it just doesn't quite work that way.
That's the whole point. And so, yes, we got so much to get into when we're talking about Miranda rights and warnings and how and when they apply. And you just heard, we're just getting started on that. You may go ahead and call someone, say, this is a show that you need to watch. It's so important to you to get this information. So it may be a neighbor, it may be a friend, it may be a family member. Go ahead and call them and tell them about the show that we're talking about, Miranda rights. So we also want to hear from you. You might want to have a call with an attorney at Hollis Wright. All you have to do is call 1-844-LAW-TALK. You can reach someone right now, standing by to take that call while we're on this show. And that call is free. It's also confidential. We're going to take a break. We'll continue on with the conversation. Miranda rights when we come back.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show in 2011, my goal was to do what our firm does best. Help people answer questions related to real-world legal issues they have in their lives in a way that's not intimidating to talk with a lawyer. If the issue is important to you, it's equally important to us, and we're ready to talk with you at no cost.
Yeah, oftentimes people are confronting various legal issues in their lives that really run the gamut of a lot of different legal practice areas such as bankruptcy, criminal law, civil law such as personal injury, divorces, domestic relations. And to be able to have a show once a week that covers those practice areas and answers people's questions in those areas, that's really the main objective of the show.
We use the resources of the many lawyers at our law firm to create a plan that has a lasting impact for each person that calls or texts. And we also give back to the community at the same time. We are here to serve you, the viewer, each week on The Attorneys.
Did you know when you have to take a case all the way to trial, there is almost always insurance involved? Don't take on large insurance companies on your own. Our attorneys are standing by right now to give you a free consultation. At Hollis Wright, your result matters.
Welcome back to The Attorneys. We're learning about some real important law, Miranda rights, as we're speaking with Elizabeth Hunter. Thanks so much for being with us as we continue to unpack this whole very important topic.
Yeah, Elizabeth, let's talk a minute about the process that the police would typically follow if they're dealing with an individual. They've read the Miranda rights to them, and probably against good legal counsel, they still want to talk, okay? And so they're going to waive their Miranda rights. What do the police typically do? Is it just a verbal waiver where they might record you waiving it, or do they actually have you sign some documentation?
I mean, more often than not, it is a written waiver. Now, there may be situations where they don't have that on hand and they may just have it recorded. But most of the time when they are in custody and subjected to interrogation, it's at a police station and they have those waivers available. And as soon as you sign that, of course, then that's basically you're giving up those rights. But it also depends on, even when you are giving them up, it also depends on, of course, like age, your mental defect. I mean, of course, we won't know until after the fact as far as any mental disabilities. But even when you do waive them, there are some avenues that we can take to kind of get those out.
Yeah, I guess, did the police have any sort of obligation to identify or suspect maybe that somebody's incompetent? I mean, I guess they can just continue to go down the process and hope for the best to try and get information. But
yeah, I wish there was a bright line with that. And of course, if it's obvious, if you see someone that may have some sort of mental defect, but more often than not, they just have to say, do you understand these rights? And make sure that they read them to them prior to asking them that.
Well, what are some of the limits in terms of duration of time? What are some of the limitations and restrictions on the police if somebody is voluntarily or waiving their Miranda rights and talking to them? I mean, can they keep them in the interrogation room for 8 to 10 hours without food and water? Like, what are some of the limitations?
As far as them being subjected to interrogations
Correct.
And then after custody?
Yeah.
And I think that goes with one of the cases after that 1966 case. But once they do waive those rights, of course they can, whatever statements that they would want. But then once they are released, of course, they still have to, law enforcement still has to wait. And I believe the threshold is 14 days. After that, they are able to actually come and speak to them and re-question them.
Okay.
And go from there. But that only applies to the Fifth Amendment, that right to counsel and the self-incrimination part.
Yeah. Can you take back the waiver? In other words, can you rescind it halfway through and say, I don't like the direction that this is headed?
Absolutely, absolutely. They can definitely take it back. And at the same time, and law enforcement, they know that they have to kind of reiterate that, and they have to know that, hey, I've been given my Miranda rights, and at first I did invoke it. Now I actually want to revoke it and have the opportunity to speak further, which we don't want, but at the same time, that option is always available.
Without giving names of clients, of course, but what are some of the, I guess, a couple of situations maybe that you can recall where some of your clients or you found issues with the Miranda rights, either not being given properly, not handling the waiver properly? Get the viewer some ideas to what you see in your practice.
At least from the situations, or my client situations, it's one or two things. I have some clients where they have a mental disability, but it's not obvious. And of course, it looks like they're waiving it, and it looks like they understand. And even officers, from their perspective, it appears as if they do. But when we start to go into like medical records, that's when we realize that there was a defect there. Or situations where maybe the officer may have missed you have a right to counsel. They may just say you have a right to remain silent. And it's usually, whether it's a subjective standard, of course, but it's typically after the fact when we find out. That's unfortunate, simply because it's either they waive it or they don't.
If they waive it, they're not voluntarily asking you, hey, well, maybe we should have Elizabeth Hunter come down and talk, be here beside you.
Exactly.
They want a shot at them without the lawyer there, right?
Exactly. Yeah.
And Carter alluded to some TV shows and the things that we hear on these TV shows when we're watching some of these law shows. What about some of the common misconceptions? Are there many misconceptions about Miranda rights and warnings that you're given?
A lot of my clients think that they always apply, and they don't. There are times, which rarely happens, where an officer can just come up to you and just question, and ask how you're doing. There's nothing wrong with that, which means that they're not required to provide you the Miranda warnings. But at the same time, once they start to dive into maybe a specific crime that they're trying to investigate, and if they feel like that may be the suspect, whether they're charged or not, I think that's when that applies. But just regular police encounters, it doesn't always apply, and that's the misconception, because on these TV shows like Law and Order and things like that, they think that they always apply. And of course, law enforcement is intimidating when they approach you. But I've seen many officers just want to have a casual conversation, and I think that's where that misconception lies.
Yeah, we've talked a lot about the waiver side of it and showing a willingness to talk to the police officers. But if somebody invokes their Fifth Amendment privilege, if they're read their Miranda rights and they say, yeah, I'm not talking to you, I want a lawyer, sort of what happens then? Is it self-explanatory? They terminate talking with you?
They're supposed to just stop all conversation, and that's under the Fifth Amendment. Now, the Sixth Amendment is a little bit different. Now, they have that right to counsel, but it's specific to a particular offense, and you have to be charged with something. And it's after indictment. Pre-indictment it invokes that Fifth Amendment against self-incrimination, as well as a right to counsel. Yeah, and that's a really good point. Before we go to the break, I think it's important to understand the difference between the Fifth Amendment and the Sixth Amendment. The Fifth Amendment against self-incrimination goes more with the Miranda rights, that you don't have to talk to the police and voluntarily give them admissible statements regarding your own culpability. The Sixth Amendment applies essentially after you've been charged, that you've got a right to have legal counsel defend you for the crimes that you're charged with. Yeah.
So as always, you see on this show, you get good information, good legal information, and even advice about the various topics that we cover each Sunday night. We want to thank you for joining us. Also want to remind you to follow us on all of Hollis Wright's social media platforms. That's X, that's Instagram, and also on Facebook. And you can get information there as well and find out what's going on. You can also get in contact with an attorney at Hollis Wright. Pick up the phone, dial 1-844 Law Talk. On the other end of that line is an attorney from Hollis Wright, and that call is free and it's confidential. We're going to wrap up, in fact, with Miranda rights when we come back. Stay with us. The Attorneys continues right after this.
Thank you for watching The Attorneys each Sunday night, where we come to your living room to provide free legal advice in a confidential, off-air setting. Unfortunately, with the number of calls, texts, and emails that come in during the show, we can't always get to everything. But know this, Hollis Wright is open all week long. You call us at 844-LAW-TALK and we're going to answer your question for free. Thank you for watching The Attorneys, and we look forward to seeing you and talking to you soon.
You see us each Sunday night on The Attorneys, but remember, our attorneys are here all week long to help you with your personal injury claim.
Our attorneys are standing by right now to give you a free consultation at Hollis Wright. Your result matters.
Welcome back to The Attorneys. So glad to have you with us. We're talking about Miranda rights, warnings, how and when they apply. And our special guest is Elizabeth Hunter as we get into our last segment on this subject.
Yeah, absolutely. So one of the components to the Miranda rights talks about you have a right to an attorney, and if you cannot afford an attorney, one will be appointed to you. So let's talk a little bit about that. Obviously, I think it's self-explanatory that you have a right to an attorney if you invoke the Fifth Amendment privilege against self-incrimination. But let's talk about the affordability component of that. Are there thresholds that you have to meet to show that you're either below a certain income level or poverty line? What is the requirement there?
Yeah, and a lot of people know that they can have an attorney to represent them, but there are many others that just can't afford one. And in the courts, they don't want to put them in positions where they don't have proper representation or they don't have an equal shot in proving they're innocent. So those, you're right, such as those with low income, and most counties you have to fill out like an application, and the judge will basically assign or appoint you counsel. It depends on the amount of income that you bring in, whether you're married or single, your kids, things of that nature, and at that point the court will determine whether or not you meet that threshold. I've seen many times where they would fill out the application, it would be denied, and it would force them to actually have to pay for private counsel. I don't really see that often, but it's usually the judge that decides that, and at least from what I'm used to in the courts that decide whether or not that's the case.
Is the decision by the judge influenced by the crime that you're charged with and sort of the projected amount of time and effort and energy a defense lawyer would have to apply to defend you in that case? In other words, like if you're charged with a felony DUI as opposed to capital murder, obviously those are two very different crimes.
Definitely two different offenses. And there's a higher threshold when we're talking about capital offenses, and that involve the death penalty. But misdemeanors, maybe something as low as, and I'm not going to say low as, but DUIs, which would be deemed almost like a traffic offense. Right. Oftentimes they don't even announce that, if you can get court-appointed counsel, but it's still there. But as soon as we get higher into the felonies, like robbery, burglary, and things of that nature, that actually involve some serious prison offenses, that's when they start to, the appointed counsel becomes more of an effect.
And I think it's also important for the viewers to understand, too, that the lawyer that you get appointed, they have to have a certain level of experience based on the crimes that you're being charged with, right? Like if you're charged with like a capital murder crime, doesn't the lawyer have to have a certain number of years in handling like certain felonies and things of that nature?
Yeah, and the judge will actually know, and I believe for capital offenses, any attorney that is appointed, and they have to do some sort of educational classes on those capital offenses or courses. So that part the judge will already know. But as far as the robbery and you assume that they would have those experiences. But yes, you're right. 9 times out of 10, it has to have the attorney has to have some sort of experience in that area.
So, talk a little bit about this, because I think this is intriguing and is also very important. Is that I know impulsively a lawyer might say, "Don't ever talk to the police if they're interrogating you, and there's any chance that you could be the target of the investigation. Just don't talk to them." But I think that's easier said than done, especially if you're dealing with somebody who is truly innocent. They did not commit the crime, but the police want to talk with them. And they may be of the mindset that, no, I want to talk to them because I didn't do anything wrong, and I don't want them to think that I did something wrong by me saying I'm not talking to you. And I think that's a difficult decision to make, but sort of what advice do you have in that regard?
It's almost like a risk versus reward, in my opinion. You have to kind of balance it out. And you're right. I mean, my clients will come to me and say, I didn't want to talk to them at first, but they kept thinking that I was guilty when I didn't want to talk to them. But then at the same time, no, if they really didn't do anything, they feel like they can just say whatever. And oftentimes it's not about what you say, but it's often whether or not it conflicts with what you said before.
Right.
So even just contradictory statements just hurt you. And sometimes people just don't remember. And they may say something last week that may be a little bit different this week. And it's not because they're lying, they just can't remember. So I tell them that you have a right to invoke that right. The right is there, and if you want to remain silent, you can do that. And courts know that you can't bring that up, and you can't use it against them, especially during a trial. You can't use it to just assume that they're guilty or for any impeachment purposes.
Well, and as you were answering that question, sort of a thought came into my mind where it becomes particularly difficult. Let's say you're dealing with a kidnapped child, right? Major red flags if mom or dad walk in and say, yeah, I'm not talking to the police, right? Well, you don't want to find your child.
Exactly.
So, but I mean, that's a situation. It happens, right?
Yeah.
And the parents have to walk a fine line in terms of their cooperation and how helpful they want to be, knowing that I think the statistics show oftentimes that the parent or a family member are in fact involved in the kidnapping, right?
Yeah. I mean, and the right's there. Just use it. And I know it sounds so simple, but you're better off not saying anything at all, so that we don't have to try to clear that up later.
And I'm just wondering if there have been any advancements or any proposed changes in the Miranda warnings that we should be aware of.
And the most recent change is that the 14-day threshold that I was referring to, and before that, once people got out of custody, those kind of remain. Law enforcement couldn't actually speak and re-question these individuals. After the fact, now they have to, once they get released, they do have to wait just a little bit, and they can still approach them, but they have to wait a certain amount of time to do that. And that did give law enforcement a little bit more threshold to re-question maybe about a new case or another case. But it helps in a sense that it does solve more crimes, but at the same time it does invoke more false confessions, in my opinion.
Yeah, we're winding up the show, but talk really briefly about the comments made in an interrogation versus what I'll call an excited utterance or a statement you see in the back of the police car where they just extemporaneously say something, and how that can be used.
Yeah, an interrogation is basically you're just answering the officer's questions. If you go outside of that, I just deem that as a voluntary statement, and they can be used. So the thing is, and I let my clients know, so long as you just, for one, you got to remain silent, but so long as you don't answer the interrogation questions, of course, or vice versa. But the interrogation piece more so purports to you directly, addressing what the officer is trying to say, or at least trying to question. And if you do that, that would be deemed an interrogation. Now, an interview would just be basic questions like maybe what's your name, where were you, things of that nature. But once it starts to go towards or directly towards what the officer is trying to ask, knowing that the officer is trying to elicit some sort of criminal response from you, then that would be deemed as an interrogation.
Thank you so much for being here. It's been a great show,
Thank
Elizabeth.
you.
Yeah, really do appreciate it. And we also appreciate you watching us here on The Attorneys, and invite you to make that appointment to watch us again next week, same place, same time. We'll do it again with good information that matters to your life. So long.
Thanks for watching The Attorneys, sponsored by Hollis Wright.